We brought this petition because, as a lawyer, I've been working for so many years with the people who have been arrested and put in jail on the basis that they were found walking on the street and they could not explain who they are, couldn't give a good account of themselves, or they were found walking in public places where they are not supposed to be walking. So as a result of that experience, and also having done a lot of litigation in the Constitutional Court, I developed a conviction that this law needed to go off our books because it was unfair.
The Constitutional Court of Uganda has declared as null and void sections 168(1)(c and 168(1)(d of the Penal Code Act of Uganda. These provisions are part of the broader range of legal provisions creating the offences of being rogue and vagabond. This judgment is a welcome development in the struggle for the decriminalization and declassification of petty offences that have traditionally been used by law enforcement to target and harass marginalized persons on the basis of status in Uganda. 68(1)(c of the Penal Code defines as rogue and vagabond any suspected person or reputed thief who has no visible means of subsistence and cannot give a good account of him or herself. Any suspected person or reputed thief who has no visible means of subsistence and cannot give a good account of himself or herself. And section 168(1)(d defines as rogue and vagabond any person found wandering in or upon or near any premises or in any road or highway or any place adjacent thereto or in any public place at such time and under such circumstances as to the conclusion that such person is there for an illegal or disorderly purpose. The African Commission on Human People's Rights passed principles which required that governments should decriminalize petty offences in Africa, and the same was actually approved by the African Court on Human and People's Rights in an advisory opinion. So for us, we are really happy.